Good morning, ladies and gentlemen. Thank you for coming for this press conference. My name is Valentine Maponga. I'm the spokesperson for Veritas. Today we called in here to unpack a judgment that we believe is of great importance in the running of affairs of our local authorities. It's a court case that we took, that we sponsored as Veritas. It was done by Combined Residents Trust, Borodale Residents and Ratepayers Association. It was also, we had also Harare Residents, Clever Rambanapasi, Ian Makoni, and Elvis Ruzani. So we were challenging Section 314 of the Urban Councils Act that we felt we gave the local authority minister a lot of power in terms of the running of affairs of our local authorities. And with me here is Honorable Tendabit. He's a lawyer who argued our case in court and we won it. So he's here to just unpack it to you guys and advise on the way forward in terms of this important constitutional case. Up to you.
Thank you, Valentine, and good morning, members of the Fourth Estate. So I want to begin by appreciating Veritas for supporting this important test case. The issue in this case was that, as all of you know, the Minister of Local Government, he has a power which was in Section 314 of the Urban Councils Act, Chapter 29:15, which allowed him to give a direction and to reverse any decision made by a local authority, whether it's a policy one, whether it's an administrative one. So the minister, in terms of Section 314, had extensive powers, and this power was used very capriciously, very maliciously, to thwart the aspirations of local authorities, to frustrate local authorities. And the context of this court application, as you know, was that in 2022, the seat of Harare's council took a decision on the 9th of July 2022 to reverse and suspend the contract that it had ended with for the Pomona dump site, the George Nicks dump site. So we were instructed to challenge the directive by the minister to reverse the seat of Harare's cancellation of that agreement. And ironically, that application is actually going to be heard tomorrow in the High Court. But it was in the process of this case that it became obvious that challenging the minister's directive, and even if we were to win, the minister tomorrow would just issue another directive. So it became so obvious that we needed to challenge the provision of the law that empowered the minister to make these unlawful decisions. So Veritas, working with the residents of Harare, the Combined Residents Association, Chira, the Borodale Residents Association, Councillor Ian Makoni, residents of Harare like Clever Rambanapasi, and also Honorable Alan Norman Makam, Rusty Makam. They were very key in this litigation. So what was in issue before the court was the constitutionality of Section 314. And what we were arguing is that the Constitution of Zimbabwe in Chapter 14 creates two things. Number one, it creates and recognizes the principle of devolution of power and the principle of decentralization of power. And it is very clear that developmental issues shall be determined by residents and citizens. Chapter 14 is a very citizen-centric chapter of the Constitution that recognizes that citizens must make their decisions. Citizens must govern themselves. In fact, Section 276 uses the word govern. Citizens must govern themselves, and they govern themselves through elected representatives. So it's a process of participatory democracy. So we argue that if the Constitution says citizens must govern themselves, citizens that they elect at local authority level, at provincial authority level, and the minister is not elected, so surely Section 314 is unconstitutional. So the principle of devolution is recognized. The principle of self-governance is also recognized. Third is the principle of giving power to the citizens, empowering the citizens to make decisions. We are very pleased that the High Court of Zimbabwe wrote a very interesting judgment. This judgment advances the jurisprudence of Zimbabwe, the legal history, the legal culture of Zimbabwe, because it emphasizes the value of devolution. It emphasizes the constitutional value of legality. A minister can only act if that which he's doing is permitted by the constitution. And so the judgment essentially says that to the extent that the minister, an unelected individual, in fact, he has the power to run a seat of Harare through Section 314, that Section 314 was inconsistent with the Constitution of Zimbabwe. In terms of the law, this judgment now has to be confirmed by the Constitutional Court in terms of Section 175, subsection 4. So we hope that the matter can be heard in the first or second term of this year. But for now, every local authority must know that they've got a judgment. And if July Moyo were to write to them in terms of Section 314, they must say to him, "Staff you, Mr. July Moyo, you have no right to do that." So we're very pleased with this judgment. And so we're grateful to Veritas. We're grateful to the lawyers here. As I've always said, these constitutional cases, all of you will see the judgment, but what you will not see is the endless, thankless hours that lawyers put in behind the doors researching. Constitutional cases, I always say to young lawyers, are very difficult cases, because you are trying to design. Then when you design, you are trying to destroy a prior thinking. Then you are trying to put a new house where the old one was. And our courts generally tend to be very conservative. So pushing them and changing the law is a lot of task. And we are very privileged as Tendai Biti Law and we're humbled by the fact that we've been doing it constantly, changing the law, bending the law. And I want to thank Veritas, I want to thank Zimbabwe Lawyers for Human Rights, I want to thank individuals like Rusty Makam and others who have been brave enough to say, let's do it, it's our law, it's our country. Thank you very much.
Thank you very much, Honorable Bit. You can ask any questions that you feel you may want Honorable Bit to expand further. I'll share with you the copy of the judgment. I do have a soft copy, so I'll share on WhatsApp and even on emails. Yes, Blessed.
My name is Blessed Mhlanga from HSTV. I just wanted to find out, after this judgment, the challenge on the Pomona dam site, does it not become moot because the judgment has already been given that the minister can actually not rescind decisions by a local authority? So what effect does it have to that challenge?
So there are two separate challenges. The first challenge is challenging the law. So this judgment has nothing to do with what the minister has said. It has nothing to do with what the minister has actually done. This is just clarifying the law. The relief we got here is called a constitutional declarator. A declarator is just clarifying the law. You now need a judgment that says what you did on the 9th of July, what you did on the 18th of July, what you did on the 12th of October, when you wrote to the seat of Gweru or seat of Gwebi is unlawful. Seat of Gwanda is unlawful. So this is why the challenges, and there are many, around the Judgement are important. And as I said, tomorrow, the High Court will hear whether the minister's actions are lawful. But what this judgment does now is to leave the minister very naked. When we go to court tomorrow, the minister is very naked because is now his actions are now illegitimate. Paternity has been denied to him because the courts have said, but that which you are relying in, it's unlawful. So he's now very naked. So this judgment then strengthens those judgments. So it's a very important judgment. I think that July Moyo in particular, July Moyo in particular has been very notorious for abusing Section 314. And many of you will remember the countless times that July Moyo has suspended mayors, has given directives and so forth. So this is the end of it. And part of the problem we are seeing is that July Moyo is not harmonized local authority laws with the constitution. The elections are here in a few years' time, in a few weeks' time, in a few months' time. And there were people that were elected in 2018 who are provincial councillors. Provincial governance are there. Devolution monies are being given to people, but that law is not there. So July Moyo has been one of the worst executive persons because he has not dared to harmonize the law. Why? Because it leaves him powerful. And he then remains an emperor. He then remains a little god, dishing out sludge funds as he has been doing to devolution, suspending mayors and councillors willy-nilly. This judgment says you can't do that. Councils are run by the people. Provincial authorities are run by the people. Just like central government, it's also run by those that are elected to do that. If a councillor, if the mayor of Harare can't interfere with central government can't also interfere with Mayor Jacob Mafumi. And I need to say that that there are a number of provisions that give central government power that interfere with the independence of local authorities. So we have challenged Section 314, but there are others that are outstanding. The first one I want to give is Section 81. Section 81 of the Urban Councils Act allows the minister to suspend elected councillors. He can't do that. So that one has to go. There's also a provision, a creature called the Local Government Board. The Local Government Board is a board that was created by Chombo to say if the city of Harare wants to employ anyone or to fire anyone, the local government board must approve. That's interfering with the independence of a local authority. A third provision that has to go is the provision in the law that says that says the budget of a local authority must be approved by the minister. Why should the budget of a local authority be approved? They're independent, they're self-governing. It must be approved by the residents. So I can appreciate a law that says the Minister of Finance through a Public Finance Management Committee must make sure that any budget actually fits with the revenue and the macroeconomic assumptions of a local authority. So a local authority can't say we want a $2 trillion budget when it's collecting 40,000. I can understand that oversight. Maybe we should give it to Parliament. But to simply say a budget of a local authority needs the approval of a central government minister, it's clearly unconstitutional. The last thing which affects all of us is the provision of the law that says when local authorities need to procure, they have to seek approval of central government. Why central government? I can appreciate a procurement authority for local authorities somewhere, but not central government interfering with them. Lastly, borrowing powers. If a local authority wants to borrow, the Minister of Finance and the Minister of Local Government must approve. Why? They're independent. If they want to borrow, they go to a bank will do its due diligence and look at the balance sheet of the local authority and determine whether there's capacity. But if a local authority wants to borrow and be guaranteed by the government, yes, the government must say, we can't guarantee you unless we are sure you can repay. That's a different thing. So there are about 4 or 5 provisions which I've just mentioned. And I hope other lawyers can pick this up, because this judgment gives them this power. The Urban Councils Act, the Rural District Councils Act have not been amended, and local authorities are treated as a department in the Ministry of Local Government. And when you have a malicious and capricious minister like Honorable July Moyo, then you have a problem. You have total emasculation of local authorities. And local authorities in the past 5 years have been emasculated by Minister July Moyo. They can't collect the refugee, they can't fire people, and they are blamed, but the real problem is Minister July Moyo of Herbert Chitepo Avenue.
Any more? Yes.
So, as you said that our councils are failing to deliver their mandate because of local government minister. I mean, people have always asked the question, so why should people bother electing local councillors and having mayors with all their work when they are asked for responsibility, they blame central government?
I think the attitude of people and the attitude of citizens, and I know their position, is that nothing about us without us. Let us govern ourselves so that you judge us correctly. So these laws must go. It's a pity that we have to go to the courts. In other countries, they'll be marching. In South Africa, there'll be demonstrations. In South Africa, this victory will not be a court victory. It will be a victory obtained in the streets. Because you cannot have this anomaly that your councillor is just a figurehead, that your councillor is just like makeup that you can remove in the evening. They have no substantive power. That's not good enough. Thank you very much.
Thank you very much, colleagues. Like I said, I'll be sharing the judgment with you guys on WhatsApp, or you can share your email addresses, then I can share the judgment. Thank you so much for coming.